Good morning, everybody, and welcome to another edition of Talks on Immigration. My name is Attorney Carlos Wetton. Please stick around and stay with us. Today, we are going to be talking about a very interesting topic, K-1 fiance visas. So hold tight, and we will be right back with the show. Good morning, everybody, and welcome back. I'm so happy to be here with you all to discuss a very important topic, K-1 fiance visas. Now, unfortunately, I am by myself today, so you're just going to have to listen to me explain, but I promise this information is pretty useful and it's very interesting, especially if you've watched reality television within the last few years and you're familiar with a few shows that deal with bringing in people to the United States and specifically for the purpose of getting married. So that's what I want to start with. What is the purpose of the K-1 visa? So the K-1 visa is specifically created to bring fiancés of United States citizens into the United States for the express purpose of marrying here in the United States, and therefore then applying that they can apply to become legal permanent residents. So the K-1 visa, really, that's its only purpose. That's the only reason why it was created, was to bring fiancés of U.S. citizens here to the United States for purposes of marriage. But the larger question is, who qualifies for a K-1 visa? Does anybody qualify? Well, unfortunately, K-1 visas can only be given to fiancés of United States citizens. That's the first requirement. So unfortunately, if you're a legal permanent resident and you would like to petition for your fiancé, the K-1 visa is not the way to do it. In fact, as a legal permanent resident, you can't petition for your fiancé to enter the United States. Now, so it has to be a fiancé of a United States citizen with plans to marry once they enter the country within the first 90 days. So that's crucial. So one of the requirements of the K-1 visa is that you have to plan to marry your fiance of the United States citizen within 90 days of their arrival into the United States. Now, the person also has to be free to marry. So that means they can't have an active marriage to someone else. All marriages have to be completely terminated, both for the United States citizen and for the fiance that resides abroad. Now, in fact, yesterday I had a situation with someone who is engaged to a person from the Philippines. However, that marriage of that fiance in the Philippines is still active. In fact, the Philippines does not allow for any type of divorce. And so what we're waiting for is for the fiance to get their marriage annulled before the petitioner can bring the fiance here into the United States. So that's an important thing to remember. All marriages have to be terminated and the person needs to be free to be able to marry. Now, one of the final requirements for a K-1 visa that's probably one of the most interesting is that there has to be some kind of physical meeting or interaction between the petitioner and their fiance within the previous 2 years of submitting the petition. So this means that they have to have met in person and spent some time together and have proof or be able to prove that they were physically interacting with each other sometime within the previous 2 years before the petition is submitted. Now, this is a pretty hard requirement. However, there is a waiver available if the U.S. citizen petitioner can demonstrate that it would be difficult or the hardship to visit their fiance abroad, or if they can say that meeting in person would violate some kind of long-standing and well-known cultural tradition of the fiance. So this means that if there is a significant hardship, for example, if you've met your fiance online, but there's a significant hardship and you cannot go visit them, within the previous 2 years before you file the petition, you can still file for the fiancé visa, but you're going to have to demonstrate that it's too hard for you to meet them in person, or that it violates your fiancé's long-held cultural practices. Now, a fiancé visa or the K-1 visa has a little bit of a timeline. So we're looking at the first step in order to request a fiancé visa is to file what's called a petition. So the petition is an I-129F fiancé visa petition. Now, this petition is filed by the United States citizen, and it's submitted in the United States at the local immigration office, USCIS. And so the petitioner has to submit the application to USCIS, and then we're looking at a processing time of possibly about 6 months to 18 months before that petition is approved. Now, that doesn't mean that it will take 6 to 18 months for your fiance to come to the United States. What it means is that it will take 6 to 18 months for the petition to be processed and approved at USCIS. Once it's approved, then that approved visa petition will be sent to the National Visa Center, and your fiance will be able to submit an application for the visa itself. Now, since your fiance is going to be abroad and not in the United States, they will then at some point be scheduled for an interview at the United States Embassy or the United States Consulate, where they will be able to kind of answer some questions from the consular officer, and the consular officer will also make a determination as to whether or not you and your fiance meet the merits of the petition. And so they will make a decision as to whether or not to approve the actual visa application. But once it's granted, it will be valid for 6 months. So that means that your fiance will have 6 months to come to the United States. And once they enter the United States, as we've already discussed, you have this very strict timeline where the fiance and the U.S. citizen petitioner will need to get married within the first 90 days of arrival. And so that's a pretty hard and fast rule. So what happens then? Let's say your fiance comes to the United States, but you don't get married within those first 90 days. Well, the most important thing is that once those 90 days elapse on that K-1 visa, and they are not married, your fiance will be out of status. So that means that they will be accumulating unlawful presence here in the United States after those first 90 days. However, let's say that you decide you need a little bit more time to get married, and you get married after the 90 days have elapsed. That doesn't mean that you're suddenly out of luck and there's nothing that you can do. The petitioner, United States citizen petitioner, will then just need to file what's called a family-based petition, and then which is a completely separate process from the I-129F fiance-based petition. So let's say that your fiance enters the United States, that you've gotten married within the 90 days, but let's say that your fiance has children as well. So you have, he or she or they have children that they would like to bring with them to the United States. So as long as the child is under the age of 21, and will be under the age of 21 when they enter the country with you, they would be eligible for a visa to either accompany the principal, so which means to accompany the fiance to enter the United States at the same time, or within 1 year after the fiance enters the United States. So again, children of a fiance or of a K-1 visa holder are eligible to enter the United States under their own visa. It's called a K-2 visa, as long as they are under the age of 21, they're either accompanying the fiance under the K-1 at the same time, or they are joining within 1 year after the fiance's arrival into the United States. So this is an important benefit. So if you have somebody, a fiance, that wants to enter the country, but they don't want to leave their child abroad, now you know that they can bring their child with them, and it doesn't require a separate petition. It could actually be included on that I-129F form. but the child receives their own separate visa, which is a K-2 visa. Now, let's say that you've entered the United States, you're a US citizen, you're here, your fiance's here, you got married within the first 90 days, and they had their child, and their child is here. What we're going to talk about is what comes next. The important step of, okay, well, they're here. They have the status of a K-1, but what comes after the marriage? What are they eligible to do? That's when they're eligible to file for what's called an adjustment of status and to file for residency here in the United States. Both the fiance and the derivative child under a K-2, they can file for adjustment of status if that marriage took place within the first 90 days after their arrival. And actually, what we're going to talk about next week, or what we're going to talk about next time, is we're going to talk about what's that residency process like for someone who entered with a fiance visa, or also for somebody who has a family-based petition and they're eligible to apply for residency. So I hope I was able to answer some questions for you that you might have regarding a fiance visa. Please do not forget to reach out to us if you would like a consultation. We at Jaime Barron have offices in the Dallas and Fort Worth area, in Washington, D.C., and our brand new office in the Seattle area where I am the managing attorney. So if you would like a consultation over the phone, in person, via Zoom, if you would like to have a consultation with me, you can always give us a call. Our number is 206-274-1400 to schedule your consultation with me or any of our wonderful attorneys here at Jaime Barron PC. So thank you for listening and tuning in. And next time we're going to talk about residency. I hope everybody has a great week.